Lawyers, of course, owe a duty of loyalty to their clients. So you can't take two clients who's have conflicts of interest um, at the same time. So concurrent conflicts of interest. So let's say, well, here's the easiest one. If there's an automobile accident and there's, of course, one party that believes the other caused it and the other party believes the other, you can't represent both of them. You can't represent two clients on the opposite side of a conflict. But it also means you can't like represent two separate parties in a contract dealing, because you can't represent one fully if you are representing the person on the other side of that transaction. You owe a duty to your former clients, but the rules loosen things up a little bit here. If you have a client and they are truly a former client, you haven't had any dealings with them for a while, and there's no real time limit, but probably a few years, and you haven't communicated with them since then, the general rule is you can go ahead and represent someone who is suing or having a transaction against a former client, as long as the work you're doing for the new client is not substantially related to the work you did for your former client. Like, for example, if you negotiated some employment contracts for a corporation, and then 5 years later, after you'd done that, you hadn't worked for the company at all, they're truly a former client. One of those people that they had that contract with wants to sue them. You could not take that case because you're the one that made that apparently crappy contract, and you could not, again, sue your former client because it's substantially related. It's the same dying issue. All right, so former clients, general rule is you can go ahead and get in there. So, or if you have confidential information that it would help your current client too much. Like if you were going to be suing your former client for something completely unrelated to the work you did for them, maybe you did an adoption for this person a long time ago, and now they're involved in an automobile accident, and when you were doing the adoption, the person didn't seem to have a lot of money, but they confided in you that they had a couple of $1 million in offshore accounts in the Canary Islands. And that would be very good information to know if you were suing this person now. And so because of your knowledge of confidential information that would be really good for your new client to know, you couldn't take that case. And you couldn't give up that information either. So all these conflicts that you might have with other, with current clients or former clients, any conflict you have is going to be what we call imputed to the entire firm you work for. Now, if you work with two people, big deal. But some firms have, over 1,000 lawyers. And so if one person has a conflict, the entire law firm is deemed to be conflicted out as to that client. Now, it got really untenable about 25 years ago because big firms used to be like 25, 30 lawyers. Then it became 100, then 200, then 300, then 500, then 1,000. And so it was getting really difficult to not have these conflicts that were going to be imputed to everybody in the firm, and it was going to make it very impossible for clients to get the type of legal representation they wanted, and of course, for the lawyers to get the fees they wanted. There it is again with the money. What's with this guy? Anyway, so there is a relaxed rule when these conflicts occur because someone is moving from one firm to the other. So if someone is representing client A and then moves to another firm where A was suing client B, now that imputation, you couldn't have this lawyer because it's a fiction that says every single lawyer in that firm represents every single client. And so that would be a conflict of interest. They would have to drop the case. However, to allow people to move from firm to firm, they can be screened. So what happens is when you learn of the conflict, the lawyer shall have no more information about anything about the case. They won't get any part of the fee that's going to be coming in from this case. And the other party has to be notified that they're being screened, what are the screening procedures, and so that they can monitor. If anything's fishy, like how did they know that? They would be able to go ahead and investigate whether or not perhaps that information could only have come from the allegedly screened lawyer. Probably shouldn't say this, but you know me. I love to tell a story. when this first started, this screening process, they allowed it first for government lawyers moving from private practice to government practice or vice versa. And they called it a Chinese wall. You put up a Chinese wall to screen someone from any of this information and money. And the idea was that's the biggest wall in the world. It goes on forever, right? It's a bulwark against any kind of chicanery. But in the beginning, the lawyers were not so good at respecting the wall, and it kind of became a derogatory term, like that's just some sort of Chinese wall, as if it was an inferior product of some sort, like from China. And I think now we've got it pretty well straightened out where screening can be monitored and it is effective. So more duties as an advocate. Gatekeeping and diligence. We talked about diligence already, but gatekeeping as well. You can't take every case that comes down the line. People want to sue for crazy things, and sometimes it's just it can't be done. It's just outside of the scope of the law. It's not a result that the law will allow. And you have to go ahead and, again, with candor to the client, let them know that you can't take that suit for them. You can't go into court and take a case you know is going to lose to harass someone. That's against the rules. It's against, we'll see later on, against the rules of civil procedure as well, but it's against the model rules. And of course, diligence. You gotta see things through. You can't have endless delays. You've got to work diligently to settle the matters that you're undertaking for your client. You also have a duty for candor to the tribunal. And this is really difficult to convince my students because we start them out, looking at the law as objectively as possible, and then we start introducing them to being advocates. And once they get that advocate hat on, they are impossible. They take no quarter. They want to pursue every advantage for their client, and the other person, they just as soon drown them in the river. Anyway, not that bad, but they are lawyers in training. But candor to the tribunal includes this one thing that is really difficult to convince students about. And that is, if you know of, let's say you're looking at case law to bolster your client's case, and the other party, they missed a case that would just completely tank your argument. They didn't see it. They didn't put it in their briefs. You have a duty to put it in yours. You have a duty to inform the tribunal about any law that is directly against your case, even if the other party didn't find it. And that's an affirmative duty, and you must do it. Now, a good lawyer will bring it up and then show why it shouldn't apply in this case, maybe show why the law should be changed, but you can't just not bring it up. Also, you can't make any misstatements of fact to the court. And of course, lawyers shouldn't be doing a lot of statements of fact because you're not supposed to be testifying in the trial. You're supposed to be bringing the testimony out of other people. But you cannot lie to the court. Lawyers have a duty to be fair to opposing parties as well. And, this comes about with evidence. You can't hide evidence. You can't tamper with evidence. There's some really interesting little cases here. Those of you old enough to remember Xeroxes of Xeroxes of Xeroxes, where they got really fuzzy, like white specks all of them, black specks all of them, hard to read. Some interesting cases where someone in a law firm, I think it maybe even was a secretary, the case I'm thinking of, decided it was really difficult to read the document and was trying to white out some of the black spots and fill in some of the lightness so that the document could be more legible. But that, of course, is tampering with evidence. You just have to give what you have. Some really interesting cases, but of course, you don't burn evidence that's bad for you. You have to, again, it's all part of that whole idea of candor as well. The rules of civil procedure, which I know you talked about with Professor Pierce. Isn't she great? I mean, who doesn't love Professor Pierce? She probably mentioned something about the rules of procedure where a lawyer will be violating the rules of procedure by bringing a case they know they have no possibility of winning. There's a little exception for cases that you think it's going to be tough, but you're really trying to advance the law. You're trying to change the law a little bit so that we can improve the law. That's not going to be the same thing as no possible chance at all. And then in trial, again, you have all sorts of fairness rules concerning opposing parties. You have to respond diligently to requests for information and evidence. You have to, there, surprisingly enough, is a duty for decorum in the courtroom, of course. You want to make sure that you are, not being a total jerk. Excuse me. And let me just see. Impartial, and again, your book reminds you. I'm just taking a peek here. Very few cases make it to trial, and so, we don't want to have these unfair tactics. And my favorite one, I think it's in here, but if it's not, is someone feigning a heart attack or a stroke or a seizure to get a mistrial because the trial wasn't going well for them. That's not fair. If you're not ready, you're not ready. That's your fault. But you can't, do something like that to get a mistrial.